Copyright Act without any warrant. Now, powers of police in cases of copyright violation done by the end user. An end user commits offences again, section 63 and 63B. Section 63 is a generic offence, unauthorized installation and reproduction of during use. 63B, special provision, knowing use of unlicensed copy. Power again, section 64 you have the same powers as in case of an individual. The same powers can be invoked under 64 against the end user as well. Now, sometimes what happens, there's a question. Okay, police will do a raid on slow motor. So whether the copyright owner is required or not? Legally speaking, no. The copyright owner is not required. Infringement established by the existence or non-existence. If you go and search the premises, you can ask for the license copies from the premises owner, from the company guys. You can say that give me, okay, you are using 100 computer systems, show me 100 licenses. If they are not able to provide it, they are indulging in infringement of copyright. Existence of license peculiar to the knowledge of the user. Owners, again, under section 106 of Indian Evidence Act, onus is on them to prove that they are using licensed copy and they are not using unlicensed copy. So there is no onus on the copyright owner. So hence, the copyright owner as such is not required when you conduct a search and seizure operation under Copyright Act. There is a very important case, landmark case again, state of Andhra Pradesh versus Nagoti Venkatramana. 1996 PTC 634 decided by the Honorable Supreme Court of India. It says, any person could set the criminal process in motion. Anybody can complain, file a complaint. Suppose I buy a music CD, it is not running on my DVD player or CD player. I can go and file a complaint with the police and say it seems to be a duplicate CD. So I can set the law or the process in motion. Now, what again the Supreme Court said, owner of copyright need not be traced or produced as witness to establish infringement of copyright, paragraph 11 of the judgment. Title could also be proved by filing notarized or legalized certified copies of extracts of copyright register, section 79 of the Evidence Act. Because it's a public document. It's a publicly available document, and if you file a certified copy under Evidence Act, that can be proved. Now, in the recent past, there are some judgments which are slightly contradictory in nature. As I said, the copyright offence, infringement or a trademark infringement is cognizable non-bailable offence. In Amarnath Vyas versus State of Andhra Pradesh 2007, Criminal Law Journal 2025 is the page number, AP. Amarnath Vyas filed an application for anticipatory bail under section 438 of the CRPC after being accused of an offence under section 63 of Copyright Act. So, when you require anticipatory bail? When you are apprehending arrest. Okay? So, you file for anticipatory bail. The public prosecutor contested that since the maximum sentence of such offence is 3 years, it would fall under second category of offences under part 2 of the schedule 1 of the CRPC. The court dismissed the above contention and held the offence to be non-cognizable, and what it observed, whether the second category of the classification will attract or not is the only point germane for the consideration in the instant case. That is the only thing to be decided. The expression, punishment for a term which may extend to 3 years is certainly not similar to the expression 3 years and upwards. Okay, so 6 months to 3 years is not the same even though up to 3 years includes 3 years. A maximum sentence of 3 years can be given, so 3 years is included there. But it is different from 3 years in which again the 3 years is minimum can be given 3 years. So 3 years and upward, but they are not considered to be the same, and hence the court said it is not a cognizable offence, hence you don't require an anticipatory bail. Now, there is a contradictory judgment. Kerala High Court. The Kerala High Court, in the case of Suresh Kumar, son of Kumaran versus the Sub Inspector of Police, 2007 3 KID 363, it said, while adjudicating upon the question whether copyright infringement is a cognizable offence, the court premised its reasoning on the fact that punishment of the offence is imprisonment of 3 years. Now, the other way around. As it is a 3 year, so it's a. Now, what it was said, Section 63, according to me, is clearly punishable in imprisonment for 3 years, and in these circumstances, the offence has to be held as cognizable. So, this distinction between the two judgments prays for a more, obviously, still the Supreme Court has to decide. Now, the stand which was taken by Andhra Pradesh High Court was again taken, was upheld, or you can say the same thing was followed by the Delhi High Court as well. And in the recent judgment, Delhi High Court in the NCT of Delhi versus Naresh Kumar Garg, criminal major MC 3488 of 2012, the Kerala High Court stand was again reversed, and the judgment of Amarnath Vyas versus State of Andhra Pradesh was upheld. The respondent was arrested for an offence under Section 63 of the Copyright Act, and his plea for anticipatory bail was rejected on the premise that such an offence is a bailable offence. So obviously you don't require anticipatory bail. The court, while holding the offence the non-cognizable, observed in paragraph 13, it would be fruitful to refer to the provision of Section 64 of the Act, which empowers a police officer not below the rank of sub-inspector to seize the infringing copies of any work. If the offence had been cognizable and non-bailable, there was no necessity of specifically authorizing a police officer with the powers of seizure. So, there is a special power which has been given to police, and hence the Delhi High Court said, as especially this clause or this particular section is there, so if the offence would have been cognizable, non-bailable, this particular provision was not required. It's a special case which has been given to under this Act, under Section 64 of the Act. Now, see, sorry. I was told to combine both the sessions, so I think it will be much easier for us. Now, who is liable where the end user is a company or a partnership? Vicarious liability under Section 69. All those responsible for the conduct of affairs of the company, like directors, partners, IT managers, all those persons are liable for this particular offence. Knowing use is necessary to establish offence. Obviously, proof of accused having received educational material or warning letters about software management. What happens? There are various these big software companies or even the big broadcasters. They keep educating the clients or the customers. They send letters to them, telling them about the use of licensed copies or properly proper subscription for their broadcasting, their channels and all. So they keep sending these educational letters. So if these letters have been sent, and in spite of those letters or notices, the party has indulged in that particular act of infringement of copyright, so that is a knowing use of infringement. I don't think I have to tell you because you are well aware of this. that how to conduct an end user action, but just to give some pointers. Obviously, anywhere, any raid, first thing you do is to freeze the location. You freeze all operations upon entry, conduct software audit, inventory. Obviously, if it's a software raid, you'll ask for the license copies, product name, versions, number of copies installed, number of licenses they have, or how many systems they are using. All these information inventory has to be made. Make an inventory of software documentation, and obviously all this seizure and all this inventory has to be made on the location. You cannot bring everything to police station and then make the inventory, but you have to make it on the spot. That is the requirement of law. Now, obviously, invoices and licenses you need to compare, ask for original media. There can be two types of licenses. One can be box licenses you get, or one can be a paper license where there can be multi-user licenses. In one paper it will be written that this is a software number and there are 100 users which are allowed under the same number to use this. So you may find some 100 systems with the same number. So it can be a license copy as well. Obviously, installations, if they don't match with the licenses, those are infringement. You need to take printouts of directories of the hard disk, remove the hard disk, seize the computer itself, enter details of hardware seized with software audit, and then you can prepare the seizure memo. Now, obviously, if we are doing some actions, there will be some challenges as well. So, what are the challenges? Right holders challenges, investigation challenges, and prosecution challenges. Right holders challenges is like until 2000, police insisted on written complaints being furnished by authorized representatives of the corporate owner. Responsibility to produce these persons after 3 to 4 years at a time of trial. Expensive proposition as date upon date may be given by the court. Difficult to find persons with integrity. These are all right holders challenges, what they face day-to-day basis. Then this Nagpur Amendment came in 1996, which is very helpful. Delhi police especially has done lot of stolen motor actions without any complaint or so. So that can be followed by other police, the other state police as well. What happens? Obviously, the company issues a power of attorney to a particular person, maybe of the local area or something like that. So sometimes that power of attorney is even misused by the power of attorney holders. They may indulge in some kind of extortion or something like that. That can also happen. So the right holders face these kind of problems. It's very difficult to find people with integrity and honesty who will just go and use the power of attorney as per it has been given to, or other than go and extract money from the market or something like that. The information is there, but they don't want to come forward and they are not ready to give the complaint. Obviously, everything is commerce. It involves huge budget. People have to be flown from one side of the country to other. So there can be technical experts. All these expenses, there every day, day-to-day hearings are happening. So it's a very costly affair as well for the right holders. And obviously, it's a very limited exit route. So obviously, they have to be part of, as a witness, they have to appear in the court. But in civil cases, if the matters can be settled, then they can come out of the proceeding. Here, they will have to go for a 482 quashing of FIR under section 482 of the Act. Now, what are the challenges which are faced by the investigating agencies? Obviously, by the police. As I asked before I started my presentation, very few, one or two of you have done the IPR cases. So obviously, there is not much exposure towards these kind of cases. These cases do not happen every day, or at least the the owners of IPR do not come forward every day to take action against these kind of infringement. So you are not exposed to this kind of criminal offense. So obviously you don't have the trained professionals or who can distinguish between the pirated or the genuine product. So obviously you require cooperation from the right holder. So there has to be much more interaction between the right holders and the investigating agency or the police. Obviously there are like IPR cells now which are there in various state police. I think it's there in Andhra Pradesh as well. Bangalore, Karnataka, I have seen. Jaipur and other parts of the country, Delhi police has a very good IPR cell. So these kind of IPR cells can also be very helpful in taking or at least helping police to understand the matter and then proceed with the investigation. Obviously these are low priority matters. There's a very important case we did for Microsoft where the raids were conducted at 16 locations simultaneously with the help of CII, and huge amount of the software was seized. So that it was a very, because what happens, suppose I file a complaint in Hyderabad, if they have to conduct any raid in Delhi, obviously you will have to go and meet the local police station, take their permission and then go to the location. But CBI has a overall jurisdiction, so they can do that kind of action which can involve multiple states. So that is another issue. These are some of the, you can, just to maintain that okay, everything has been done properly, video filming can be done. Even very few FSLs, the forensic science laboratories which are equipped with the digital products, because obviously they are not receiving that kind of samples every day. Even the proprietor and main accused, sometimes they run away from the location or are not mad. So that is another problem. Illegal public exhibition of film or police show licenses, like they show the cinematographic film or CV that CBFS certificates, the censor board certificate, which is not the copyright certificate. So sometimes they show that as well. Obviously, cable piracy, Mr. Mann will be dealing with that. And it's difficult to find a police team late in the night. What happens, like sometimes the matches are happening in the morning, like the World Cups. It starts 3 o'clock in the morning sometimes. So it's very difficult to find police officer or a complainant at that time and conduct the raid, because we have to do the raid when the act is happening. Or it is difficult to find the source of the feed. Somewhere in some corner they will be sitting with a decoder, they will be downlinking and just putting it on the cable. Obviously, as the police is not conducting many actions, very few cases are going to the court. So the public prosecutors even are not very familiar with these kind of laws, or not comfortable with these kind of laws. So CII has done past many, I think, interactions with even public prosecutors as well in various parts of the country within the district courts. So they have taken some initiative on that, and we have been going and meeting with those guys, and we are having sessions with them on IPR. So even you can appoint a special public prosecutor, a person who is well versed with this law can be a special public prosecutor there. Obviously, the cases reach after 3 to 4 years, witness becomes hostile or is not available, not traceable sometimes. Memory loss is the very standard answer. Storage of seized products kept in extremely hostile conditions. Obviously, these are very delicate. A CD or a CD writer or any decoder, these are very delicate equipment. So it has to be kept in a very special manner, but it has all put in the sack and if you put it in the malkhana. So it may not work when actually it has to be seen whether it's a pirated CD or not, whether it is working or not. So that's another problem. Obviously, the courts have to need to be more sensitized in intellectual property violations. Now, the title of the foreign copyright registration certificate we can file again. As I said, certified copies can be filed or legalized copy along with the charge sheet. Summons, you know that under section 91 CRPC, whatever is there in their possession, then it can be asked for. Copyright registration certificate, US Copyright Office is public document under section 74 of the Evidence Act. Proof of certificates through certified and notarized or legalized copy can happen, so you don't require the copyright owner as such to be present there. Presumption has to be as genuine under section 79 of the Indian Evidence Act. So works first published in India, certified copy issued by Copyright Office, presumption as to genuineness without requiring any further proof. I don't know whether visible it is. This is a sample of copyright certificate which can be shown by the owner. Copyright registration, but as such is not required.